You know, when we talk about policies concerning the homeless crisis, there's really two big court cases that control what cities can and cannot do about people camping. The big one was out of Boise, Idaho, but there's another one here in Oregon, the city of Grants Pass. We've told you about it before, and it just took a major next step this morning, one that could influence homeless policy across the West Coast. So that is our big story tonight. You're looking at a petition to the U.S. Supreme Court, our nation's highest court, from lawyers representing the city of Grants Pass. They want the 9 most powerful justices in the land to take up their case and make a final ruling. That's obviously a big step, but will the court even hear the case? That's the first thing that would need to happen, and it's certainly not a guarantee. Let's explain why and find out how we got here in the first place. Let's start with the ruling out of Boise, Idaho that I mentioned. The case is called Martin v. Boise. In 2018, the 9th Circuit Court of Appeals ruled a city cannot charge someone with a crime or give them a ticket for sleeping in a public space if there's no shelter beds available, if there's a lack of shelter beds. In other words, nowhere else for the person to go. The judge declared that charging someone with a crime for sleeping outside when they have no other choice is a violation of the 8th Amendment. That means it qualifies as cruel and unusual punishment. Boise asked that the full 9th Circuit review the ruling, and they said no. So they petitioned the case to the U.S. Supreme Court, and the court then denied the request to even review the ruling. That happened in December of 2019, which means that ever since then, that lower court ruling has stood in that case. Now, the path of the Grants Pass case so far has been exactly the same as that of the Boise case, although we've not yet heard from the Supreme Court yet. In 2022, a 3-judge panel from the 9th Circuit Court of Appeals agreed with the lower court, ruling that Grants Pass cannot enforce its camping ban. That ban would punish homeless folks with civil citations for sleeping in public places, even if there's nowhere else for them to go. So the city appealed, asking the full 9th Circuit Court to hear the case. Sound familiar? Last month, that appeal was denied by a single vote. And that leads us to today. The next and final step the city can take to try and enforce their camping ban is to ask the Supreme Court to review it. Now, it's worth noting the political makeup of the Supreme Court has changed greatly since they denied hearing the Boise case. That might be the reason why lawyers for the city of Grants Pass think they have a better chance now for the court to take the case. Justice Ruth Bader Ginsburg died in 2020 and was replaced by conservative Justice Amy Coney Barrett. This was obviously the biggest political change. Justice Stephen Breyer retired last year and was replaced by Justice Ketanji Brown Jackson. Conservatives still hold a 6-3 majority, with Chief Justice John Roberts sometimes surprising us with moderate opinions, but that still gives the conservatives a 5-4 advantage. The lawyers representing Grants Pass obviously hope the court is ready to rule differently on the homeless camping issue. They released this statement this morning. The 9th Circuit's decision in this case and Martin v. Boise have contributed to the growing problem of encampments in cities across the West. These decisions are legally wrong and continue to tie the hands of local governments in their efforts to devise solutions to the complex problems of homelessness. The tragedy is that these decisions are actually harming the very people they purport to protect. We wanted to interview the lawyers to ask more questions, but they said, no thanks. And here's the big question presented to the U.S. Supreme Court. Does the enforcement of generally applicable laws regulating camping on public property, does that constitute cruel and unusual punishment prohibited by the 8th Amendment? We expect to hear a decision from the Supremes on whether or not they'll even take the case, either late this year or early next year. But in the meantime, we'd like to hear from you. What do you think? Put on your imaginary U.S. Supreme Court justice robes and then share your thoughts and your reasoning. Are camping bans cruel and unusual punishment and therefore unconstitutional? If so, why? If not, why not? And we all want to hear what you have to say about that. Either send us an email or call us. You can email us at thestory@kgw.com or call and leave a voicemail 503-226-5090.